You're watching House Habits with House Counsel. We are about empowering resilience and delivering practical solutions. Today we're exploring copyright in the employment context under Australian law. In this fast-paced digital era, it's crucial for employers and employees to understand how copyright works in the workplace. Copyright is basically any creative output that is literary, musical, dramatic, sound recordings. So you think in the employment context, it's frequently things like marketing materials, written content, even some music in things like record labels, etc. But in today's digital age, creativity and innovation drive business forward. Think software, for example. The writing of the code is potentially copyrighted or is copyrighted. It's a literary work. But in the midst of this creativity, there's an important aspect that both employers and employees need to be aware of. This copyright in employment idea. In Australia, the concept of copyright ownership in the course of employment is significant when determining who owns the copyright to a work created by an employee. When a work's created by an employee during their regular employment duties, the copyright is generally owned by the employer. The term work made in the course of employment covers creations directly related to an employer's job, such as software development, design work, marketing materials, just to name a few. It's important to remember that the creation must be part of the employee's regular duties and not something unrelated. So say, for example, you're employed as a software developer, but you decide to write a children's book. The children's book isn't in the course of your employment. It's not going to be automatically owned by your employer. This doesn't mean that the employee has no rights over their creative production. Australian copyright law provides that certain rights are still given to employees, even if the employer owns the copyright. These rights are generally known as moral rights. The right of attribution, for example, not saying that a work belongs to somebody else or was created by somebody else when it actually wasn't, and not changing or adding to the work that would have a negative impact on the creator's reputation. These really important moral rights help safeguard a creator's identity and a creator's effective moral rights. It is important to know that you can contract out of these obligations. There are some circumstances where it's just not practical to attribute a specific employee the creation of that work. For example, multiple software developers, things like that. So big picture, you should always give proper credit to employees for their creative contributions, and it's only fair, right? So if you do require them to waive their moral rights because of the practicality issue, then make sure that it's embedded within their employment contract. It's important to understand that this doesn't apply to a contractor or a freelancer. They usually retain their right to copyright. So as I mentioned in the contracting video available on this YouTube channel, make sure your intellectual property assignment clause is clear if you require ownership and not just a license to utilize it from a contractor or a freelancer. So to conclude, understanding copyright in this employment context is essential for employers and employees. The respect that it creates of respecting the copyright ownership and authorship rights help foster a creative and harmonious workplace. It's really important that as you approach the employment relationship, genuine respect is there, and employees understanding employers have rights and employers understanding that employees have particular rights is really important to creating that harmonious workplace. So this has been House Habits with House Counsel, and thanks for watching, and please don't forget to subscribe.